see the banner coming up when that's kicked in.
Okay, she's giving me
Thanks.
Okay, thanks, Shireen. Okay, good morning, everybody, and welcome to those in attendance at this remote meeting of the local review body of Aberdeen City Council. My name is Councillor Mary Bolton, and I'll be chairing the meeting today. Councillor Donna Clark and Councillor Avril Mackenzie are also in attendance and will be participating. Please note that the meeting will be recorded and published online for public access after the meeting. You are also reminded to note that we may have members of the public or press observing today's proceedings. Can I ask those who are observing today's meeting to keep their microphones and cameras switched off throughout? Can members of the review body leave their cameras on but mute their microphones when not speaking? As the local review body contains quasi-judicial business, members are reminded that they should not leave the meeting during consideration of any of the reviews. This meeting has been convened in response by 2 requests for a review of the decision taken by the appointed officer under the Council's scheme of delegation. Members of the local review body have before them copies of the review documents as listed in the notice calling the meeting. Members of the local review body have before them, it's twice I've got my notes. I will now ask Mr. Masson, the Assistant Clerk, to outline the procedure to be followed and to conduct these reviews. Mr. Masson.
Apologies for that.
That's okay.
Members have the procedure note which was circulated with the meeting papers and is intended to set out the wider framework within which the review process operates. From this, it is clear that the first task for the review body is to come to a decision on whether the review documents contain sufficient information for the case to be determined without further procedure, and by that it is meant without further information or representations. To assist, I feel it would be helpful to mention the following. Firstly, that the regulations governing the local review process require that all matters which the applicant intends to raise in the review must be set out in or accompany the notice of review. Secondly, that the focus of the review should be on the basis of what was before the appointed officer when a decision was made, and only in exceptional circumstances will new or additional matters be permitted to be taken into account. Thirdly, to note that the modernisation of the planning system, which included revisal of the planning appeals process, of which this local review body is part, removed the previous right on the part of an applicant to insist on a hearing and replaced that with the local review body, providing them with the power to choose a procedure which more accurately reflects the facts and circumstances of the individual case. And lastly, that guidance issued by the Scottish Government's Chief Planner in 2011 stated that reviews by local review bodies should be conducted by means of full consideration of the application afresh. This review should take the form of a structured discussion led by the chairperson to consider the matter set out in the notice of review before you. And I would conclude by drawing your attention in particular to points 10 to 12 of the procedure note. Thank you.
Okay, thanks very much, Mr. Masson. Okay, now turning to the consideration of the first review in respect of the decision to refuse the application for the erection of a first floor extension at Kirkalley Cottage, 8 Charles Place, Aberdeen, AB253TW, planning reference 220267/DPP. We will now hear from the planning advisor in attendance, Mrs. Lucy Green, who will provide us with a brief description of the application proposal and a reminder of the reasons why the application was refused. I would point out that Ms. Green attends today's meeting to provide us with the necessary professional planning guidance because she has not been involved in the earlier consideration of the application under review. Ms. Green will, however, not be asked to express any views on the merits of the proposed development, and in fact, her role will be a neutral one involving the provision of factual information and guidance only. And with that, I'll pass over to you, Ms. Green.
Thank you, Councillor Bolton. So I'll just share my screen with you. Just one moment.
That's it. Perfect. It's up for us, Lucy.
Okay. Yeah, I'm just moving it to the format where I can see my notes. Right. So this relates to a request for review against an application refused under delegated powers for the erection of a first floor extension to form a double-storey house at Kirkcallie Cottage, which is accessed off Charles Place. And the review has been submitted with all the necessary information within the time limit of 3 months following the decision of the appointed officer. So the decision notice was dated 16th of June and the notice of review was received on the 6th of July. The applicant has indicated on the notice of review that there were no new matters raised in the submissions. However, it's been noted that there is additional information provided in Appendix 9 to the review statement, and that consists of the shadowcast information relating to the impact on 9 Charles Street. So it's for the LRB to make a decision on whether they wish to consider that information.
Okay, I'll maybe take in Mrs. Christie to give us some advice, members, before we make that decision.
Yes, so Lisa Christie, your legal advisor to the Planning and Environment Committee, and as said by the clerk, Mark Masson, so everything that the applicant intends to raise in the review should be set out in or accompanying the notice of review, and as should all documents, materials and evidence on which the applicant intends to rely. Section 43B of the 1997 Act restricts the ability of parties to introduce new matters at the review stage unless they can A, demonstrate that the matter could not have been raised before that time, or B, that it not being raised before that time was a result of exceptional circumstances. Or that it's material to the determination of the case. However, if it was decided by the LRB that this information was material to the determination of the case, then what would need to happen is that the applicant and other relevant parties would have to be allowed to make representations, on that new evidence. However, I do think that in this case, the information was not before the appointed officer at the time, so I think it would fall into Section 43B of the 1997 Act. If there's any other questions, I can try to answer them.
Okay. Can I just ask, because clearly that there's I suppose a dispute between the applicant and officers on whether it complies with the council's own guidance. Now he refers to it on page 60, I think it is, where they're talking about the adjustments they've made to the roof height and design to comply with the 2545. I think I'm not very good at pulling up the two different things, but I made notes from on it yesterday. So, I mean, it's already referenced by the officer, and because it's I suppose a clarification by the applicant, or the applicant's agent, should I say. I mean, it's not necessarily that the actual appendix is there because it's already referenced elsewhere within the report. So I'm not so sure, whilst that actual picture may be new, and if you feel that that would be detrimental to our determination, I feel that it's referenced elsewhere in the report, that I'd be satisfied just to rely on other information within the report to be able to examine this particular subject. So if you feel, Ms. Christie, that it would be safer not to pay cognizance to Appendix 9, which is the picture showing the different impacts of the daylight, etc. I'm quite content that I've got other information in the report that I can use to reference any comments.
Yes, I agree, because it wasn't before the appointed officer at the time, so I agree not to take it into account.
Yeah. Okay, can we just agree that, members, that we won't take Appendix 9, although it is referenced elsewhere, so that we're content just to leave that aside so that we don't muddy the waters in terms of the determination. Happy with that? Yeah.
Thank you.
Okay.
Thank you.
Thank you. Okay, back to yourself on the screen.
Thank you. I'll just share the presentation again. Sorry, that's the wrong screen it's sharing.
That's okay.
It doesn't actually show what's on the screen, so I have to kind of guess. Right, we should be there.
It's there.
Slideshow. Right. In terms of procedure, by which the review would be conducted, the applicant has expressed the view that there should be a site visit to inspect the site and appreciate its nature rather than proceeding on the basis of the information submitted. So I'll first provide some background information to the case before handing back to you, convener, for members to discuss whether you wish to, how you wish to proceed.
Okay.
Sorry, I'm showing you my screen with the notes instead of the main screen, I've noticed. Just let me correct that.
This is really, you haven't written anything you shouldn't have, Lucy.
Right, swap these screens over. Sorry about this. Right, that should now be correct. So the application site, which is a single-storey granite-built house with its front and rear curtilage, and it's within a dense, largely residential area. The site's bounded by Charles Place, which is a pedestrian lane from which it is accessed, and it's also bounded by residential dwellings at 5 and 7 Charles Street, by a 7-bed HMO at 9 Charles Street, and there's the PDSA Pet Hospital, including a staff flat on the upper floor, which is to the north, and the house itself has its principal front elevation to the northeast. So the next slide is just showing the aerial photograph from 2022, and the front curtilage you can see is screened from Charles Place by a 2-metre boundary treatment. So that's just along there, that's the access in along that path, and there's a 2-metre boundary treatment there. So these are the flats on George Street that are referred to. 5 to 7 Charles Place is in this building, and 9 Charles Place, the HMO is this, and the PDSA is in this building with the flat in the upper level. The Google 3D image show this is the application property with the 9 Charles Street that's referred to just here, and the PDSA. This is street view from Charles Street, so that you can see The building to the front left is 5 to 7 Charles Street, and then to the right is 9 Charles Street, and the application house at the back there. And you can just about see the PDSA building just there. So this is the site plan as proposed, and planning permission is sought for the erection of an upper storey extension above the original dwelling to become 2 stories, and it would have a hipped roof. And this is just showing the floor plans as existing at the top, and then as proposed down at the bottom here. So the ground floor plan, stairs would be installed just here, and this would be the first floor level. And then elevations, existing single story here, and then with the additional story added. And you can see the timber cladding and then granite at the ends of that elevation, dry dash render here on the end elevations, and the metal standing seam hipped roof. This is just showing the PDSA building is just here. And again, this is showing the existing and proposed just sections through the building both ways. So this section is taking with the PDSA building in the background. And this one is looking back towards Charles Street with 9 Charles Street here and 5 to 7 just there on the right. And you can see the profile of the existing roof and then the extension. And these are elevations showing the 45-degree angle here that's referred to in the policies, so I'll come to that later in the presentation. I won't move on to those. So that's just come back to those tests later in the policy section. So in terms of reasons for refusal, these are stated in full in the report of handling, but the key points are that the design, detailing and materials would lack architectural compatibility with the original building. The excessive scale and form would dominate the original building. That the upper story would affect privacy, sunlight and daylight of neighbours and would be overbearing. And in particular, there's reference to privacy in the flats at 506 George Street to the west, the sunlight, daylight and outlook for the staff flat at the PDSA. It's also considered to be contrary to policy H2 and D1 in the adopted plan and the householder supplementary guidance, and also to policies H2, which is mixed use areas, D1, which is design, and D2 amenity in the proposed plan. So in terms of the applicant's case, they put forward the case that the impact on the neighbour at the PDSA to the north has been resolved by adding a 3/4 story with a hipped roof, and it's the setback of the upper story from the existing building. That the drawings submitted demonstrate compliance with the 25 and 45-degree rules. That any development of this nature in a city centre may lead to a reduction in amenity. However, the proposals don't have a significantly detrimental impact. They make the point that an additional story inevitably adds height and mass to the building. That they say that they looked at the option of adding dormers, but that didn't work from a design perspective. That the materials proposed are the existing stonework which is reused from the chimney. There's larch cladding, grey dried ash to the end sections, and a metal standing seam roof. And they give various examples of where these are used extensively within the city. Yes, including the example at 90 Lock Street, which there are photographs of in the submissions. So in terms of consultations, there were no objections from the roads team, and there were no comments from the George Street Community Council, which does appear to be active. So I'll hand back to you, convener, to decide on how to proceed. Thank you.
Put my mic on. Hi, sorry, I forgot to put my mic on there. We now need to consider whether we have sufficient information in front of us today to take a decision on the application. Members, remember that if you do not feel you have enough information to take the decision, you can request further written information be provided, hearings be arranged, or a site visit be undertaken. Now, there was a request by the applicant to be able to appreciate the actual location itself, that we may wish to take a site visit. I have had a quick look myself, and I'll listen to members, and then we can decide whether a site visit is necessary. Councillor Mackenzie.
I feel that a site visit would be beneficial.
Okay, Councillor Clark.
Likewise, I feel a site visit would be a benefit to this.
Okay, well, that's fine. I mean, I'm equally happy either way. So, but we always like to go with the majority. So, we'll pause this meeting now, this particular determination, and we'll set up a site visit, and then we can have the rest of the hearing. So, Mr. Masson, if we can make arrangements for that.
Yes, I'll do that. I'll arrange with the applicant's agent as well to see if we can get any access, which the board might want to have a look at. Sorry, the body, not the board.
Okay, that's super. Okay, members, thank you. So that's the first review for today has been now paused to carry out a site visit. Okay, now turning to the second review in respect of the decision to refuse the application for the change of use from guest house to form 3 residential flats, including alterations and the addition of window door openings at the Antrim Guest House, 157 Crown Street, Aberdeen, AB 116HT. Planning reference number 220423/DPP. We will now hear from the planning advisor in attendance, Ms. Green, who will provide us with a brief description of the application proposal and a reminder of the reasons why the application was refused. Again, I would point out that Ms. Green also attends today's meeting to provide us with the necessary professional planning guidance, because she's not been involved in the earlier consideration of the application under review. Ms. Green will, however, not be asked to express any views on the merits of the proposed development, and in effect her role will be a neutral one involving the provision of factual information and guidance only. And with that, Ms. Green, over to you.
Thank you, convener. Let's try and get the slides up quickly.
I think you've got your notes again.
Yes, it's right. Let's try that again. Okay, it's because you have to, it's the order that I do things in that
That's the
is
location
slightly
plan,
awkward.
obviously.
Right. Just take it back to the, it's very slow to respond as well. Right.
You're all set
Finally.
to
Okay, this relates to refusal under delegated powers of the application at 157 Crown Street, and it's the Antrim Guest House for change of use from a guest house to form 3 residential flats, including alterations and addition of window and door openings. So the review was submitted with all the necessary information and within the time limit of 3 months following the decision of the appointed officer. So the decision notice was dated the 11th of July and notice of review received 18th of July. The applicant indicated on the notice that there were no new matters that had been raised in the review submissions. And in terms of procedure, the applicant has expressed the view that the review may proceed on the basis of the information submitted. So I'll now continue to provide some background information to the case before handing back to decide how to proceed. So this is the location plan, and the site consists of a 2.5-storey granite-built tenement building and its associated grounds to the rear, and it's within an inner-city residential area. The principal elevation fronts onto Crown Street and the northwest side fronts onto Wellington Place and adjoins residential flats to the southeast. And also there are residential flats at 21 Wellington Place, and they bound the curtilage to the northeast, sorry. And the building is used as both an 8-bed guest house across the basement, ground, first and second floor. And there's also a separate commercial unit on the ground floor, which is the beauty salon. So I'll just show you aerial photographs and 3D images. Yeah, slides to move on. So that's the aerial photograph from 2019. And you can just see the premises there with the yellow pin stuck in them. So the front's onto Crown Street, which is here. And that's the sort of modern single-storey rear extension, which is onto Wellington Place, just there. And also 3D images. So that's the guest house on the corner there, with the beauty salon on the ground floor, and then this is the rear extension, and existing car parking here in the yard. And then there's a second 3D image just looking from the other angle to see the rear elevation there and the single-storey modern extension at the rear elevation. And then finally just a street view image of the front of the building there. So this plan just shows the boundary of the conservation area on the opposite side of Wellington Place, and there's obviously a duty to preserve and enhance the character of the conservation area. And this slide shows the site plan as existing on the left and as proposed on the right. And the proposal is for the change of use of the guest house to 3 flats. I'll show you plans in a moment. This just shows the rear curtilage area here. That's the modern extension. And you can see that within the rear curtilage, there's proposed bike racks, a single car parking space, areas of artificial turf, under seating. So moving on to the floor plans. So as I mentioned, this is a change of use from a guest house to 3 flats. And one of the flats would be a 2-bed maisonette flat over the ground and basement level. And it would have 2 bedrooms in the basement and its kitchen living room at the ground floor level in the existing rear extension. And it would be accessed by the rear elevation from a new entrance door. And also to note on this slide is the cross section, which just shows the relationship of the bedrooms here to the ground level outside. So moving on to the upper floor plans. On the upper levels, there would be 2-bed flat on the first floor with a kitchen living room with its window on the southwest elevation, and a 2-bed flat in the second floor roof space with a kitchen living room with its window on the northeast elevation. So moving on to the elevations. There aren't many physical alterations, but these would include the installation of a skylight on the rear dormer, which you can't actually see on these elevations, but it's shown on the site plan, which I had on an earlier slide if you wanted me to go back to that. The formation of a door opening on the northeast elevation. So that's here, that's this end of the modern extension. And the enlargement of the 2 basement level windows on the rear elevation of the main building. And these would serve the bedrooms of the ground and basement level flat with the bedrooms in there. There's also an existing lean-to shed within the curtilage which would be removed, and that doesn't require planning permission to do that work. So I've just added in this elevation, the south elevation, which shows the proposed window in the south side of the modern extension, and also the blocking up of an existing door opening and its infill with dry dash render. So just moving on to the street elevations, these wouldn't actually change under the proposal. They would remain as existing. So in terms of reasons for refusal, which are stated in full in the report, the first reason relates to an unacceptable level of residential amenity, and in particular, that's a low level of sunlight, daylight, and outlook to the ground and basement level flat. That the proposed rear curtilage area would not provide sufficient quality and area of space. That there's conflict, therefore, with policies H1, which is residential areas, D1, which relates to design in the adopted plan, and conflicts with policies H1, D1, D2, which relates to amenity, and the WB1 policy, healthy developments, in the proposed plan. In terms of the applicant's case, they state that they don't challenge the 25-degree rule, which I'll come to in a moment. However, they point out that this is not a new build. They point out that there have been revisions which have introduced communal amenity space within the rear curtilage, and that the area near the basement windows could be allocated to the ground and basement floor flat to ensure privacy. That the building's built around 1900 and that the accommodation has been provided within the basement for some time, with the 2 windows in existence, and that formed the owner's accommodation in the guest house. That the downturn in oil and gas has led to the closure of the guest house, and that they've considered alternative layouts, But if the basement cannot be used, then the space is redundant, and that equates to 60 metres squared and is currently used. So they state that the project's not viable with the 2 flats and that there are many similar garden flats in existence in the city. So just to cover consultations and representations, there were no objections to the application from members of the public. The Roads Development Management team had no objection, and they had no observations following the revisions, which incorporated 1 parking space and cycle storage spaces. Environmental Health had no objection, providing that if the application were to be approved, any necessary sound insulation measures are incorporated into the design of the flats. And they give further information about the levels for the insulation. The waste team had no objection, although there was initial concern that bin storage hadn't been shown. That is now on the revised plans. And finally, in terms of the Community Council, Ferry Hill and Rutherstone Community Council is not currently established, and there was no response, obviously, from them. So at this point, I'll hand back to you, convener, to decide how to proceed.
Thank you very much, Ms. Green. I haven't noted down there been any request for a site visit, had there, by the applicant? No.
No.
Just want to make sure I missed it. So members, we now need to consider whether we have sufficient information in front of us today to take a decision on the application. Members, again, remember, if you feel you don't have enough information, you can request further written information be provided, a hearing arranged, or a site visit be undertaken. Councillor Clark.
Sorry, Maria.
That's okay.
On looking at the design guide, I am still concerned about the light aspect of the basement flats, how much light is actually getting in there.
Can I just check though, if you feel at the moment, are you happy that we carry on with the yes. hearing today?
Yeah, I'm happy to carry on.
Okay, Councillor Mackenzie.
I feel there's sufficient information provided and I'm happy to carry on.
And I'm likewise. So again, we'll just hand back to yourself, Ms. Green, because the members are all content with the information in front of them.
Okay. Right, so I'll now talk about the policies that are relevant. So the site lies within an area that's zoned under policy H1, residential areas. And it states that residential development is acceptable in principle in these areas, subject to various criteria. I suppose the most relevant one there is the second criteria about character and amenity of the area, and also whether the proposal complies with supplementary guidance. And in this case, that would be the householder design guide that would be relevant there. So looking at the householder design guide, that includes mention of the 25-degree method that's noted in the case officer's report. So I just included this on a slide just to sort of explain how it worked. And basically, you take the midpoint of the affected window, so that would be the basement windows, and take a 25-degree angle to the horizontal, and then look at whether there's obstruction within that area. So that's what the case officer and applicant are referring to in that. Of relevance also the design policy, and in assessing design it's important to take into account the context. And this is just looking at the policies mentioned in the officer's report. Obviously, the main ones that were used in the reason for refusal were policy H1 residential areas and the design policy. There's also policies on transport and active travel. I mean, it's a central city centre, well, close to the city centre site, so active travel is available from that location. In terms of managing the transport impact, there's a parking space provided and the roads team don't object to the application. In terms of noise, environmental health have no objection, subject to sound insulation taking place. And waste management is covered by the bin storage that's shown on the plans. And then similarly, digital infrastructure that requires fast internet connections, which it's assumed would be available close to the city centre. In terms of the proposed plans, there's obviously a couple of policies within the proposed plan that are sort of new. And one of those is WB1 healthy developments, which requires developments to provide healthy environments. So that would be relevant in terms of daylight reaching the flats that are proposed. And policy D2 on amenity has specific reference to the levels of amenity for residents, including daylight, sunlight, and outlook. So that's those policies. Finally, in terms of evaluation, this slide is just a reminder of the primacy of the development plan and that all applications should be determined in accordance with the development plan unless material considerations indicate otherwise. So the basis for decision would be the zoning within the residential areas policy. Would the proposal comply with that? And in particular, would it provide an acceptable level of residential amenity? Okay, that's all from me, and I'm happy to answer any questions.
Okay, thank you. Questions for Ms. Green? Councillor Clark, do you want to ask about the daylight reaching the basement windows?
I was concerned about the effect of the actual light getting to these basement windows because of the side structure, and then we've got the building next to it. My concern is there's enough light getting in there, and what has been done to make it more accessible for the light getting in?
Well, that's the 25-degree rule. So obviously when you apply that, the modern extension is obstructing, you know, and if you apply the 25-degree rule, that's the modern extension that gets in the way. And that's the reason for the case officer's determination of the application.
Yeah. Councillor Mackenzie, have you got any questions?
And not really a question, but an observation. Had serious reservations about the amount of light that would be getting into the basement.
Okay.
Other than that, nothing else.
No. Again, I don't have any specific questions. The report was pretty thorough and the information was quite clear. In accordance then, members, if we have no further questions, with the procedure note circulated, the local review body will now discuss and decide the manner in which this review is to proceed. I would highlight that all representations relating to the case have been considered and taken into account. So what I need you now to do is obviously if we can discuss the merits or otherwise of the application, and we'll reach a determination on how we wish to either uphold or overturn the officer's decision. I think there's clearly concern about the lower basement, and whilst I appreciate the applicant has stated that it has been occupied in the past, and obviously when the building was built, you know, the basement was used, but then of course there wasn't the modern extension to the side. I think we're all concerned that the residents, I would suggest, on the basement are not being afforded reasonable amenity in terms of access to daylight and sunlight into those lower ground bedrooms. And my personal view would be that they haven't made headway in assuring me that they've improved the situation. So before I obviously make my final determination, does anybody else want to add anything to the discussion? No. Okay, so I'll go round you. So perhaps if we could start with you, Councillor Clark, if you could determine and give us your view on whether you wish to uphold the officer's recommendations for the reasons outlined in the refusal notice, or if you wish to move anything otherwise.
I haven't seen anything any different to make me change my view on this. I still say I'm not happy about the light level, etc. That is very concerning. We've got to take in all weathers and all conditions, and that corner can be quite dark, and it's a grave concern of mine. I haven't seen any improvement on this.
Okay, so you're saying you want to uphold the officer's recommendation?
Yes.
Okay, Councillor Mackenzie?
Sorry, I've got somebody else joining in. I'd like to uphold the...
Not lucky, she's got to be quiet for a bit longer.
I would like to uphold the recommendations.
By the officer. Okay, again, equally, I think, you know, we appreciate that this is a site that is in a residential area. I appreciate that this was probably, I don't know in the past if it was ever used as a shop on the ground floor, or if it was converted at a later date. But you know, I think, you know, we've moved forward in our design attempts, and I think amenity, and I think particularly with WB1 being introduced in the proposed plan, I think the considerations that the officer made is correct, and I think it's a unanimous decision that we will uphold his recommendation and refuse the application. Mr. Masson, do you need anything further from us on that?
No, thanks. That was nice and clear. Thank you.
Okay, thanks very much. Okay, members, that concludes the local review body for today. Clearly, we have a site visit for the first application. We'll come back to you with dates to make sure we can get our diaries together for as soon as possible, so that the applicant can get a clear understanding of where we are. Okay, thank you all very much, and see you all soon.
Thank you.
Thank
Thank
you.
you.
Bye.
Thanks.
Bye.
Bye.
Bye.